Κυρίες και κύριοι, καλησπέρα. Θα ήθελα να εκφράσω τις ευχαριστίες μου στην
Ladies and gentlemen, I would like to thank Ms. Kanelopoulou and all of the members of Institute of Sparta for inviting me today and for giving me the chance to be here with you.
passed a law, in Spartan terms a retra, that permitted a person to give intervivos or bequeath by will his household and his lot to anyone he wished. This destroyed the previous Lycurgan system, whereby lots had passed from father to son. Decedents' relatives lost their inheritances, wealth became concentrated in the hands of a few, and oliganthropia became so severe that by about 244, no more than 700 Spartiates remained, of whom perhaps 100 had land and lot. Despite the clear concurrences between Plutarch and Aristotle, which I will discuss presently, today, thanks to the work of Eckhard Schuttrumpf, Stephen Hodkinson, and others, the retra of Epitadius is frequently condemned as a fiction, but it still has its defenders, and in this paper I will add myself to their ranks. I will argue that there is no necessary contradiction between Plutarch and Aristotle, and that Plutarch is right about the retra's content, but wrong about its date. I will then discuss the ramifications of the retra for the Spartan law of gift, bequest, and other transfer of real property, and its role in Spartan oliganthropia. We have only basic information about Spartan inheritance law. Herodotus states that when a man dies leaving a never married and unbetrothed patrouchos, the kings determine whom she shall marry. A patrouchos is the daughter of a man who dies without a surviving son. Aristotle blames Sparta's laws for the concentration of wealth and the resulting oliganthropia. Permitting gift and bequest of land has the same effect as endorsing purchase and sale. About 40% of Spartan land belongs to women because of a large number of epikleroi and size of dowries. Aristotle uses the Athenian term epikleros that approximately corresponds to Herodotus's patrouchos. And when land is divided among multiple sons, impoverishment inevitably results. Between Herodotus and Aristotle, Spartan inheritance law underwent at least one change. The marriage of a patrouchos left unbetrothed by her father was now subject to the total discretion of the father's male heir. Moreover, Aristotle's observations that Spartans could dispose of land by will and division of land resulted in impoverishment shows that in his time, the Spartans practiced partible inheritance of land in some, but not all cases. The same principles must have applied a fortiori to non-landed property. A testator could thus devise his estate in its entirety to a single heir or divide it among multiple heirs. This brings us to Plutarch. Plutarch clearly describes the same legal dispensation as Aristotle, unlimited capacity of gift and bequest, with the same results. The concentration of land in the hands of a few, the impoverishment of the rest, and the consequent oliganthropia. But while Plutarch attributes the retra to the Epher Epitadius and dates it to sometime after 404, Aristotle neither names the lawgiver nor dates the law, apart from observing that its effects were rampant by 371. At one earlier point in this section of Aristotle's Politics, this is Politics 2:9 on the defects of the Spartan constitution, Aristotle mentions Lycurgus by name, but everywhere else he refers simply to the lawgiver, o nomothetis, 10 instances. The law on gift and bequest has no expressed subject. The lawgiver has to be inferred from the laws mentioned earlier in the sentence. Those who reject the retra of Epitadius commonly assert that the lawgiver must be Lycurgus, that Aristotle thus presents the law of gift and bequest as unchanged since Lycurgus, and that Plutarch therefore fell victim to a fallacy. But this argument has a fatal flaw. At least once, Aristotle uses onomothetis to refer to a lawgiver who cannot be Lycurgus. The nomothetis who created the Ephoret, as we learn later, was King Theopompus. And we can scarcely believe that Aristotle ascribed to Lycurgus the law governing the navarchy, which only became a regular office in the later 5th century. So we need not conclude that Aristotle ascribes the law of gift and bequest to Lycurgus, and such a conclusion becomes even less likely in light of Aristotle's praise of Lycurgus as one of the best lawgivers. In Politics 2:9, Aristotle condemns numerous fundamental defects of the Spartan system. The fewer of these he attributed to Lycurgus, the more justified his positive summary verdict. There is thus no compelling reason to believe that Aristotle ascribed the law on gift and bequest to Lycurgus, and good reason to believe that he did not. While this does not prove that Aristotle assigned the law to Epitadius, it does establish that there is no necessary contradiction between Aristotle and Plutarch. Now, on to the author and date of the Retra. Epitadius, says Plutarch, passed his Retra during his Ephoret sometime after 404. This is our only evidence for Epitadius, who is the sole attested Spartan with this name. Yet another prominent Spartan, Epitadas, again the only attested Spartan with the name, commanded the final relief force and was killed in action at Sphacteria in 425. This appears to rule out an equation between the two men, for a man killed in 425 cannot be elected ephor and author a law after 404. The chronology, the rarity of the names, and the distinguished positions they held might suggest that Epitadius was a younger relative of Epitadas, whose only known relative is his father, Malobrus, but it is far more likely that the two men are identical and Plutarch erred in his date and in the form of the name. Aristotle, as we saw, attests that the effects of the law were rampant by 371. Especially in deeply conservative Sparta, Epitadius's Retra cannot have produced epidemic results in less than 33 years, with an immediate avalanche of Spartan fathers disinheriting their sons in defiance of tradition and strong familial and social pressures. The Retra must therefore have been passed before, not after 404. And this in turn supports the equation of Epitadius with Epitadas. If this is the case, Thucydides' version of the name must be correct. Thucydides was a contemporary of the man, and in numerous instances, Plutarch's version of a Spartan name differs from an earlier and more reliable source. Epitadas will then have served as ephor and written his Retra before 425, when he assumed the command in which he died. Additional evidence for a date before 425 is provided by Sparta's reactions to Sphacteria. The approximately 120 Spartiates taken alive and the unknown number of Spartiates killed in action so alarmed the Spartans that they sued for peace and complied with Athens' demand that they cease invading Attica. After the prisoners returned in 421, they were punished as thresantes, tremblers, for choosing surrender over death. The Spartans disfranchised them such that they could neither hold office nor buy or sell anything. Thresantes and their female dependents also became personae non gratae for marriage. This decreased the Spartiate reproductive pool and thereby aggravated the very oliganthropia that the prisoners' recovery was supposed to mitigate. And so, sometime before Thucydides' death, Sparta restored the rights of the Thrasantes. It is highly unlikely that at any time during this period, the Spartans would have compounded their oliganthropia by permitting the alienation of kleroi to the detriment of sons or other male relatives whose Spartiate status depended on paying monthly fidition dues in the form of agricultural produce. Moreover, subsequent war casualties exacerbated the oliganthropia that Sphacteria had laid bare. And so, with every passing year after 425, the enactment of a retra that would worsen the problem even further becomes less and less likely. Sparta's behavior after Sphacteria and the demographic concerns that motivated it thus provide independent grounds for dating the retra before 425, and this in turn offers further support for equating Epitadius with Epitadas. This identification gives us a terminus post quem for his effort and retra. Ephors had to be at least 30 years old. Military service ceased at the age of 60. Hence, Epitadas, killed in battle in 425, must have been Ephor in or after 455. Assuming that his estrangement from his son occurred when the latter was an adult, aged at least 20, Epitadas must have been at least 40 at the time of his Ephoret and retra. This produces a terminus post quem of 445. Within the resulting range, 445 to 426, probability favors a later date. The gap between Ephoret and command at Sphacteria is likely to be significantly smaller than the maximum, and Plutarch's association of the retra with the Peloponnesian War is unlikely to be a total fabrication. Most probably, therefore, the retra was passed between 435 and 426. While the identification of Epitadius with Epitadas defies conclusive proof, it is far more probable than the alternative, namely that two men with otherwise unattested names so similar that they might be identical both served in prominent positions around the same time. Nonetheless, since they may have been different people, perhaps collateral relatives, I will retain the traditional designation of the law as the retra of Epitadius. So, what exactly were the terms and the legal effects of the retra? At first sight, Aristotle and Plutarch appear to differ. Whereas Aristotle's unnamed lawgiver permitted the gift and bequest of any and all landed property, Plutarch specifies that Epitadius's retra applied to a person's household and lot, the original parcel of land in the vicinity of Sparta that had been passed down in the family line allegedly since the time of Lycurgus. As others have noted, though, there is no contradiction here. For an excerpt from the Aristotelian Constitution of the Lacedaemonians records that Spartan law treated the ancestral lot differently from other real property. The latter could be sold, but the former could not. In the Politics, Aristotle ignores this distinction. The natural implication is that the same applies to gift and bequest. We can thus conclude that Plutarch accurately reports that the retra of Epitadius permitted the gift or bequest of household and lot, while Aristotle describes the resulting state of the law. The right of gift and bequest thenceforth applied to all real property. This means that before the retra, a Spartiate could buy, sell, give, or bequeath any real property except for an ancestral kleros, and after the retra, even this could be given or bequeathed, but it still could not be bought or sold. Plutarch maintains that before the retra, the ancestral kleros had been indivisible, passed down from father to a single, presumably the eldest son. This statement has been attacked on grounds including the lack of provision for additional sons and the supposed ancient Greek norm of partible inheritance. But Plutarch cannot be dismissed so easily. Spartiates owned plenty of land outside their ancestral lots, especially in Messenia, that could also provide fidition contributions. Landed Spartiates must commonly have paid these contributions for their landless relatives and friends. And even if partible inheritance was the Greek norm, Other Greeks didn't do it can be a tenuous argument when it comes to Sparta. Other Greeks didn't have the dual kingship or helot slavery or the agoge either. And partible inheritance of the ancestral kleros before the retra of Epitadius presents its own problems. Especially under Hodkinson's model of diverging devolution and universal inheritance, with all children inheriting from both parents, even if marriage within the broader kin was common, multiple generations of multiple children will have resulted in the partition of any plot of land beyond recognition or reasonable administration. This is exactly the flaw that Aristotle detects. Division of land results in impoverishment. And given that the ancestral kleroi must predate the First Messenian War, when a demand for land redistribution was rejected, I find it very difficult to believe that a regime of partability survived for over 250 years, collapsing only in the later 5th century when significant oliganthropia is first documented. I therefore accept Plutarch's account of the ancestral kleros as indivisible before Epitadius's retra. After the retra, as Aristotle attests, the right of partability applied to all land. The owner of an ancestral kleros might give or devise it entire, or might divide it among multiple children or any other Spartiates. How did this contribute to Spartan oliganthropia? The essential facts are these. In 480, the total Spartiate combatant population numbered approximately 8,000. Sparta's reactions to Sphacteria, which I discussed earlier, show that significant oliganthropia had set in by 425. 7 years later, the Spartiate combatant population numbered either about 2,500 or about 5,000. In 371, only about 700 Spartiates, out of a total combatant pool of approximately 1,200, fought at Leuctra. About 400 were killed in action, and the survivors were spared punishment as tresantes. Finally, around 244, the total number of adult male Spartiates stood at no more than 700, of whom perhaps 100 possessed land and lot. Aristotle and Plutarch attest that the retra of Epitadius played a large role in this process. The retra permitted ancestral kleroi to be given or bequeathed to and among any Spartiates. Its beneficiaries included daughters who received such land as dowry or inheritance, sons other than the previous single heir, and above all, wealthy men and women. Since wealth tends to marry wealth, daughters in possession of significant land will normally have obtained similarly endowed husbands and passed on their combined estates to their children. The wealthy could also now acquire others' ancestral plots under the legal fiction of a gift or bequest disguising a sale or a surrender by a debtor in default. As Aristotle observes, permitting gift and bequest has the same effect as permitting purchase and sale. Of course, the retra of Epitadius does not tell the whole story. The large number of epikleroi noted by Aristotle resulted not just from family planning designed to prevent the excessive division of estates, but from the deaths of Spartiate sons in war. Another major factor was the loss of Messenia, liberated by the Thebans and their allies in 370-69. This wrought disastrous effects on the Spartans. Spartiates who owned land in Messenia lost it, and the Helots who worked it. They could no longer pass these lands down to their heirs or otherwise dispose of them. Fidition dues now had to be paid from the produce of Laconia alone. And so the already severely depleted Spartiate class suffered further reduction. How might the Spartans have solved their oliganthropia before it was too late? Eventually, in 227, Cleomenes III redistributed the land of Laconia, canceled debts, and enfranchised periiki and foreign mercenaries. But this was possible only in the wake of a violent coup d'etat. Under normal circumstances, the Spartans' abhorrence of revolution, reinforced by the allegations against Pausanias the regent in the late 470s, the conspiracy of Kynedon circa 399, and above all, the Great Helot Revolt of 465 to 455, would never have permitted such drastic measures. But these were not the only options. Relaxing or eliminating the requirement of paying Fidition dues in order to maintain Spartiate status would have achieved the same goal. Aristotle believed that the Fiditia ought to be financed by the Spartan state, but, as he noted, the treasury was constantly empty. Alternatively, wealthy Spartiates might have been required to pay greater Fidition contributions so that the poor could pay less or nothing, but passing such a measure would have faced formidable obstacles. In any event, rather than enacting these or other permanent measures that might reverse the damage done by the Retra of Epitadius and the other causes of oliganthropia, the Spartans held fast to tradition. And so, as Aristotle observed, Sparta was destroyed by oliganthropia. In keeping with a suitably laconic but non-Laconian proverb, Sparta's pride went before its destruction, and its folly preceded its fall. Thank you. Ευχαριστώ πολύ.